Mark has made clear that there's a distinction between the two companies, but what he's wanted to focus on more is what Facebook has done in this area and the way that things work in content review, that there are issues of imminent harm where even political figures can have speech taken down. It is and should be an extraordinarily rare event. And it has to be on an issue of imminent harm. And Facebook has approached it that way, which is quite different from the way that Twitter seems to be approaching it now. But this is a new movement for them, and so we'll see how that develops over time.
Chris, is it possible and fair in your eyes to continue in a way where you say we're not going to get involved in any way on political speech, but we are going to take some posts down if they break certain rules? This morning in his interview with Andrew Ross Sorkin, Zuckerberg cited on health issues, for example. Is that a legitimate position to have where you can sort of say, well, we will get involved and decide whether this is legitimate in one area, but not another area?
Well, standing for having a voice and having a robust, wide-open political debate is something that the company stood for quite some time and very much wants to continue. The distinctions that are made are always going to be difficult, and that's why you develop a number of different both rules over time that get enforced around focusing on imminent harm. And then you go a step further, even with the oversight board that Facebook has put together now for those decisions to be reviewed where content is taken down, supposedly in error. Because these things are so hard, setting up an oversight is something that the company's thought is appropriate, and I think it's a great step forward to try to deal with these things in a meaningful way. Having really broad berth for political speech and to have every politician have to take responsibility for the truth or falsity and for the review of what they say is a healthy thing in a democracy, and Facebook has always tried to stand for that.
Bottom line, can the administration do anything about this?
So I'm skeptical from a legal perspective that I've reviewed what the draft of the executive order that's been circulated, and it's not clear that the White House has the authority to tell the Commerce Department to tell the FCC to do a rulemaking. It's not clear that they have the FTC has the power to do the type of review they're talking about, and it's in fact probably a First Amendment violation for the White House to tell government agencies not to advertise based on content or alleged content of sites. And so, there's a whole bunch of things legally wrong with this and constitutionally wrong with it. So the effect won't be that great at the end of the day.
What about Section 230? What do we need to know that gives these companies protections? And could that be at risk as that continues to gain momentum from both sides of the aisle about how that might not be fair and that might not be the way we want these companies to be regulated?
So Section 230 is actually designed primarily to encourage the type of work that's done in these extreme areas, in extremist speech and in stuff that's held to be outside the First Amendment, and also to allow companies a pretty wide berth on deciding how they speak in terms of what they allow on their platforms. So to the extent that that would be abrogated, you might actually get a return to some bad old days of no review of anything because everyone's afraid of liability. So, I mean, cracking 230 is something that gets kind of thrown out as a possibility or a good thing that can be examined here, and I think that the actual result of that would be precisely the opposite of what a lot of the people who are complaining about content on the internet ultimately want. But in a lot of these cases, this is political posturing.